Welcome everyone, and thank you for joining our session with our guest speaker, Professor Jules Sneerson from the Southern University Law Center. Our program is sponsored by the University of Houston Law Center and the European Union through the H2020 and Marie Curie actions. And also by the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. The next event in the series will be next month with Professor Nadia Hamad from Barry University School of Law, and that will be on March 23. For further information, feel free to visit our website, www.law.uh.edu/inner-center, where you will find the upcoming and past events of the series, and also any necessary information related to this program. Feel free to use the chat box for your questions, and in due course, we will be displaying the CLE credits. From now on, I will hand it over to Professor Victor Flatt, co-director of the Inner Center and our chair this morning. Over to you.
Excellent. Thank you so much, Aubin, and I'm so excited to see your son. It's a wonderful thing that you're being a great dad and have him there. I've been looking forward to seeing him. So I'm so delighted today, not just to participate and to see Aubin's new son, but to welcome Professor Judd Sneerson to our program today. It's very exciting, and the title of his talk is on corporate purpose, which is a nice, great play of words. I always like that one in titles of articles and things. And Professor Sneerson is, as we know, at the Southern University Law Center. He graduated from Williams College and Penn Law School, and he has been working in the areas of corporate governance, and then along with that, issues of sustainable business and so corporate social responsibility for quite a while. He's published several articles in this. He might have been before his time in a way, because this kind of thing is now really exploding everywhere. I'm very interested in it as well. So I'm really looking forward to hearing from you today, Professor Sneerson. And with that, I will turn it over to you.
Thank you, Aubin, and thanks, Victor. Thanks for having me. I am looking forward to the opportunity to share this research. It is a work in progress, so I'm looking forward to your comments, and hopefully that will make the finished product a better product. So here are some slides, which I hope everyone can see, and yeah, the subject is about what's the purpose of a corporation, and it is, as we'll see, this sort of basic fundamental issue, but also one that isn't completely settled. So here we go. The idea for the paper and the topic hit me in 2020, which was the 50th anniversary of this famous essay in the New York Times Magazine by University of Chicago economist Milton Friedman, who was at the Chicago School of Economics, and of course they're also known for law and economics. And so in this influential essay, he said that the social responsibility of business is to make money for shareholders, profit generation, and that certainly caught on, and that plus the mergers and acquisitions wave of maybe the 1980s, one decade later, it firmly caught hold in American business. But what was interesting to me was the 50th anniversary, and there was a special essays and a special issue of the New York Times with a bunch of people from all scopes of all walks of life commenting on it. It coincided with the 10th anniversary of the first benefit corporation legislation, which is, diametrically opposed in some way. It is a form of business organization. It is a corporation, but a special kind of corporation with some additional features and some additional requirements. But the basic idea of benefit corporations is that it's for companies that have, they're for-profit companies, but they have sort of a social mission as well as, a financial mission. So they are held up as, for social entrepreneurs, this is the form of business that that these sorts of businesses should take. So it's really these two diametrically opposed extreme views of the purpose of the corporation that happen to coincide in the timing of things. And so it tees up this issue. What is the purpose of the corporation? Is it, like Milton Friedman said, is it to generate profits at all costs? Or is it to have profits in balance with people and with the planet? Of course, that is the other extreme. And so, as I mentioned at the top, it's this fundamental question of corporate law. It is somewhat unsettled, and so I think it deserves more explanation. And the other reason why I think it's timely is this profit obsession that many businesses have is the cause of many of our current problems, right? We've got economic inequality, climate change, kind of radical partisanship, the opioid crisis, and just if you take a look at the news from the last couple of weeks, we have two, pretty easy examples. One is the Norfolk Southern derailment in Ohio. That was a business, or that is a business that is, doing quite well. I think the revenues are in the billions of dollars, and yet they did a stock buyback. They cut their workforce, including their safety workforce, and they spent money on, not on safety, but on lobbying and trying to deregulate and successfully deregulate some of the safety rules on railways. That's one example, and so you could at least in part explain what happened there by this, shareholder primacy concept of, we need to make as much money as we possibly can. The other example from the last week is in the Dominion voting lawsuit, where they showed some of the messages between the Fox people in contrast to what they were saying on the TV shows. The reason why they were, highlighting these conspiracy theories that they knew to be false was because they were losing viewers. They were losing market share to Newsmax and the like. And so they, in part, were repeating these things, having these guests on because they wanted to continue to, have the viewership and make money. So this concept of profit at all costs, is the cause of many of our current problems. Let me just see if the chat is okay. So the corporate law, conventional corporate law, as opposed to specific to benefit corporations, the conventional corporate law doesn't really reflect either of these two extremes. It doesn't reflect the Milton Friedman view, and it doesn't reflect the benefit corporation view. It is largely in between, and although it is also somewhat controversial, there's no legal duty in Delaware law or in any other state's corporate law to maximize shareholder profits, shareholder returns, shareholder value. And in fact, there are a lot of corporate law principles, including the bedrock principle of the business judgment rule that sort of stand in opposition to this concept, this idea that there is a legal duty to maximize shareholder wealth. There is, here are some of the arguments or sort of explanations of why there is or why there might be a legal duty to maximize shareholder wealth. Of course, there's the famous Dodge versus Ford case, which is in pretty much every, at least mentioned in every corporate law business association's casebook. And this is an old Michigan case where the court faulted Henry Ford for not giving more dividends to Ford Motor Company shareholders, including the Dodge brothers. But most people are familiar with this because it was in the casebook, but it doesn't really stand for the proposition that businesses have to do whatever they can to maximize shareholder returns. The sort of take that people have on it more recently is this is a close corporation fight between Henry Ford and the Dodge brothers that was really a close corporation case and not really a case about what is the purpose of the corporation or what is the obligation of the managers of a corporation. And so it hasn't really been cited too much beyond the close corporation issues, although it is this famous case with some big names, and so of course that's why people think, oh, Dodge versus Ford, the purpose of the corporation is to make money, as much money as you can for the shareholders. There's a duty to do that to shareholders. It's not actually cited for that, and it's not actually the case. There are some takeover cases in Delaware, the big state for corporate law, that say when the company is at sort of its end stages and being auctioned off, and similar scenarios, but a narrow group of scenarios. In that situation, then the board does have this sort of auctioneer duty to make as much money for the shareholders as they can. But those types of cases where Revlon duties kick in, that Revlon is the name of the big case there, that is sort of a narrow group of cases, and for the most part, normal governance situations for corporations, those rules don't apply, and the company can make decisions that they feel is in the best interest of the company, sort of broadly defined, and includes shareholders, of course, but also other stakeholders, such as employees and bondholders and the public and the economy and so on. They can take into account sort of the larger picture of what the corporation is and not just limited to the shareholders. There is a structural argument that's often made, which is the shareholders are the ones in the corporation, sort of who's who, that elect the board of directors. And so therefore the board of directors is beholden to the shareholders, and that is where this obligation, this fealty to shareholders arises. That's all true. The shareholder democracy is not really such a real democracy, but still there's no legal duty constraining constraining directors and officers to appease and work for shareholders, even if they want to get reelected at the next annual meeting. And so I think maybe the best couple of explanations of this notion that there's a legal duty to maximize shareholder returns is, to borrow from kind of international law lingo, there is this maybe a soft law obligation to do what they can for shareholders, but there's no real enforceable duty, and companies haven't, in the normal course, been faulted, and there have been no successful lawsuits saying you should have made more money for the shareholders than you have. And sort of along those lines, maybe the ends of corporate governance is you should make money for shareholders, but the means, how you make money for shareholders, is kind of up to the discretion of the board. And so long as the board acts, with that purpose, to maximize maybe the long-term value of the firm broadly defined, it doesn't matter how they get there, so long as their decisions are informed so long as their decisions aren't the product of a conflict of interest and they're acting in good faith. If that's the case, then the means, how they act and what they decide and what they do will be upheld under the business judgment rule, and any challenges to those decisions will fail. So those are the laws, but there are other reasons why people act how they act, in addition to, there's a legal requirement or a legal prohibition. And so two other influences on people are markets and norms. And so markets, maybe there is some pressure from the stock market, from Wall Street, they don't want to be taken over and lose their jobs, the corporate officers and directors. Often their executive compensation is based in part on the stock price, and so they have incentives for sure to pay attention to the stock price and keep the shareholders happy and keep corporate raiders away is the idea. And so markets do provide a sort of non-legal constraint on the way that business people make decisions, but the studies show that corporate sustainability is not, profit sacrificing. In fact, the studies, the big studies, and they sort of trend over time to be, stronger and stronger, show that there is a business case, a real business case for corporate sustainability. If you think of one example of why this would be, I think it's somewhat intuitive. Like if you cut down on energy costs, if you're more efficient in terms of materials, but including importantly energy, then you are saving money, but you are being more sustainable. You're not depending on fossil fuels or some rare metals or what have you. And so there are a lot of situations where being sustainable of a corporation also means that you are being more efficient and more profitable of a corporation. A couple of studies, the more recent study, the sort of big one that is cited is from Eccles and Robert Eccles in 2014, and he and his co-authors looked at low sustainability companies versus high sustainability companies, and how did those two groups of businesses fare in the market over, I think it was 20 years. And the high sustainability companies made more money than the low sustainability companies, according to his study. Like and the $1 invested in 1993, according to his study, turned into $15 and change if you invested that $1 in the low sustainability companies by 2010. But that same dollar invested in the high sustainability companies turned into $22 and change if you invested that $1 in the high sustainability companies. So there's money to be made. It's not profit sacrificing. There is this business case for corporate sustainability, and that's why I think sure there is a market pressure on business people to make money for sure, but I don't think that is inconsistent with corporate sustainability. And in fact, the idea of corporate sustainability, or at least supports this market effect on business decision makers. So efficiency, conservation, another reason why this might be true is if you think of like climate change risks, right? A company that is more careful about the effects of climate change is going to be more profitable because they will be sort of aware of what's going on and what might happen. So the law, to summarize so far this slide, the law doesn't require shareholder wealth maximization. The markets don't. In fact, there's a market argument for corporate sustainability. And then the third influence on people is norms or customs. Like this is the way that people act because they're customary ways. And so these are social norms and for sure, there has been a norm in American business to try to cater to shareholders and make as much money as you can for the shareholders. But if you kind of think of the last few years, it is sort of come to enter the mainstream that companies can make money by being more sustainable. That companies should be a little bit more attuned to more than just shareholders, to the environment, to communities and so on. And so you've got the Business Roundtable in 2019, I believe, putting out a statement. This is a conservative group of American CEOs putting forth a statement that the purpose of the corporation is to promote an economy that serves all Americans. And then BlackRock, a giant hedge fund, the head of that company said, we're going to invest in companies that take into account more than just shareholder wealth and have a pro-social purpose. And the reason, according to the head of BlackRock, Larry Fink, isn't because he is abandoning profits. He says that he is a capitalist, and these businesses make money, and that's the way that he thinks that he can do the best for BlackRock's investors. So I think. And lastly on this point is the sort of trend towards taking into account environmental, social, and good governance considerations when making business decisions or making investments. This has also become sort of a mainstream thing. So mainstream that it's now part of the anti-woke agenda that some states, including refinery states like Louisiana and perhaps Texas, and I think it's not a refinery state, but New Hampshire, some states for their pension funds are sort of explicitly disavowing ESG considerations, but it's not very smart because ESG considerations are also a signal that a company has potential profit and is better suited to profitability. So these customs, these norms, traditional corporate governance norms supported the idea of profit focus and shareholder primacy, but I think the tide is turning somewhat and being replaced by this more sort of stakeholder-centric view of the corporation, the broader view of the corporation, that it's not just shareholders, it's also these other constituencies. Switching gears a little bit to benefit corporations. So this is this new form of business with its own set of laws. So these are corporations that opt into this sort of separate regime of law. The first one was in 2010, Maryland, and now it is an option in 40 states plus the DC and Puerto Rico. Louisiana and Texas are of the 40, as is Delaware law. And so this is this alternative form, something new in corporate law. It's a related concept, and it's from the same people that gave us B corporations. The B stood for benefit, but the B corporations is this private law version of the same thing. So a B corporation is a regular old corporation that has decided to be certified by this organization, B Labs, as a special kind of corporation that has benefits to society, benefits more than just to the shareholder. So it's kind of like a LEED certified building or a good housekeeping seal of approval, and it's available to anyone in any state. Any corporation in any state can apply for the certification like a LEED certified building. If you qualify according to a survey and audit, then you can use the little B Corporation mark, which is a B in a circle, and pay some royalty to them in exchange for advice, and I guess there's a marketing aspect of it as well. So B corporations is the private certification of it, version of it, but benefit corporations is the statutory version of it. And so here are a few familiar companies that are all benefit corporations. They're benefit corporations that are publicly traded as well, including Warby Parker that make the sunglasses, prescription glasses and sunglasses. And so benefit corporations, these are for-profit corporations that are explicitly designed to benefit more than just shareholders. They all have to, according to the benefit corporation laws, produce a material benefit to society. And so there's a little bit of variation among the 40 states that have this kind of legislation. There's model legislation, but it doesn't always get enacted in the same exact way. But here are some of the features. Directors of a benefit corporation must consider or balance the shareholder interests and non-shareholder interests and societal benefits when they're operating the company, making company decisions. And so this is different from regular old conventional corporate law, where corporations, decision makers may consider these sorts of concepts. Here, directors must consider and must balance these things when making corporate decisions. There's also a benefit enforcement proceedings that shareholders of these companies can bring if they are not pleased with the material benefits that the company is throwing off. But I think, as with conventional corporations, the business judgment rule would apply here as well, and therefore, to argue that the company is not benefiting society enough or is benefiting society too much at the expense of shareholders, these decisions, just like in regular corporate law, would be protected by the business judgment rule. I think. I think because there's been little to no litigation in these companies yet. The one case that I saw looked like just sort of a general kind of fight between shareholders in the context of a benefit corporation, but it really had nothing to do with the benefit corporation. There are 6,000 plus of these at the moment, and the last feature, depending on the state, is there are reporting requirements. Sort of ESG reporting requirements, where the company says, over the last period, here is, in addition to financially how we're doing, here is how we're doing environmentally, socially, and so on. Is there a real benefit to being a benefit corporation? And so the usual benefits that are given for a company to decide to be a benefit corporation are these. There's some clarity of the mission if it is sort of baked into the DNA of the business that we are a business that is has a dual purpose. We're making money for investors, but we're also giving shoes to the people that need shoes, or glasses to the people who need glasses, or jobs to people who need jobs after having a rough time. Or being pro-environment. There is a certain clarity that comes with it being explicit and baked into the company's charter. There is, I think, not in a bad way, but there is in a kind of true way, virtue signaling that if a company is a benefit corporation, then that attracts a certain kind of investment, right? If you are a trust or a mutual fund that wants to invest in these kinds of things, then a benefit corporation obviously is highlighting that feature. And then I think for customers who are deciding, which thing to buy, buying from a benefit corporation or B corporation has a little bit of attraction. And then also for talent, for labor, right? If you are looking for a job, maybe working for a company that has this, broader community-minded purpose is a benefit as well. And so maybe in addition to investment and customer dollars, it is a way to attract a different and maybe better kind of talent. But there is the dark side of that is, since these benefit corporations are not necessarily so strictly enforced, there is what's been called purpose washing, where a company is a benefit corporation, but not really doing terribly much in order to be socially responsible or materially benefit society. Transparency is, a good that comes along with being a benefit corporation, if that is a requirement. If the company is thinking more long-term, then that's just sort of generally a good thing. If they are less sort of tied to or beholden to Wall Street, they can think more long-term. Maybe that means that their compliance is better, maybe their safety record is better, and that is sort of generally, a positive. But the law and the structure is generally the same as regular conventional corporations, with a board of directors and officers and shareholders, and that stuff largely is unchanged. And then as far as all told, is there a real benefit to being a benefit corporation? I don't think necessarily. All of these things on the slide that are benefits of being a benefit corporation, you can do all of these things without becoming a benefit corporation. You can have a clear mission, you can signal your virtues, and you can have a report on how you're doing environmentally and socially and so on. None of these things require a company to be a benefit corporation. And so I'm not sure that benefit corporations is the answer. And then the last substantive slide is, is there a better way to kind of rein in companies that are obsessed with profits and harming us in many ways? And so one category here is, changing business laws, right? So corporate laws, securities laws, these are probably hard to change, but, for example, if you required under securities laws, firms to report on environmental and social fronts as well, then, that might, because they have to report it, sort of rein in their worst tendencies. And there have been efforts to, include ESG sort of reporting for firms as a security law matter. A lot of companies do it anyway, voluntarily, but that has been one effort. I think this was an Elizabeth Warren idea. We should make the biggest companies become benefit corporations. I think a lot of these things are unlikely. Or maybe we can make benefit corporations more attractive through some sort of maybe some tax or fee structure such that it's a more attractive option for a company to go that route. Most of the social responsibility sort of progress that's been made over the last, I guess, 50 to 75 years hasn't really been in the form of corporate law. It's been in the form of these other laws like labor employment law, antitrust law, consumer protection, environmental law, of course, campaign finance, social media. So maybe the ways to rein in corporations is to rein in corporations through these other regulations and laws, and campaign finance being sort of a key one there. And then lastly, another thing is I think this is somewhat inevitable that companies will come around because people are coming around, and so maybe it's too late, but or too slow. But if we wait for these norms, these customs to evolve, and these markets to I guess convey the idea that this is a better way and more profitable way of doing business than businesses will get on board, as they seem to be doing now. And just as the C-suites of the people running businesses turn over and younger people come in, maybe that is part of what needs to happen in order to get more businesses on board with this idea of doing business in a better way. All right, so that is where I'm at, and I look forward to your questions and hearing what you think. Thank you.
Thank you so much. That was very interesting, and I have many questions, so I'm going to get started. This, let me phrase this the right way. I believe you that there is a legal case to be made that shareholder wealth maximization is not the only goal that a corporation can pursue. And yet, as you point out, and even to this day, colleagues I have in the corporate world who teach business associations just automatically say that is what is required of corporations, usually citing the Delaware Revlon cases and the ones that come from there, which you allude to. And also, you note though that you note that you may need to change corporate and securities laws. So I just want to push you a little bit on that. Does that mean that you have a legal argument that profit maximization isn't required in, let's say, Delaware law, or it's only required at the time of winding down a corporation or selling a corporation, but you think that needs to be made clearer to other people, or most people don't think that, or there's another side to that argument? So I'll stop there and let you respond.
Thanks. Thanks for that question. So I think there's no legal requirement to maximize shareholder wealth outside of that sort of narrow takeover context. And if we're talking about should we pollute a little bit more or a little bit less, or should we get rid of all of our safety workers, those aren't decisions that would be implicated by the Revlon duties. And so there's no legal requirement to do it. I think the result is, or the sort of description of corporate law is that companies can do anything so long as they are informed and acting in good faith and are not affected by a conflict of interest. And so in Delaware, there's a requirement that ultimately it has to benefit the shareholders in the long term. But I mean, I think if you are running a Delaware corporation and you make a decision to be safer, or to be ahead of the curve on environmental law, or comply with environmental law, right? Then you are acting in the best interest of the firm long term, and that redounds to the benefit of the shareholders. So I think it's there's sort of a wide area of permission for directors to manage the corporation however they feel, ultimately for the benefit of the shareholders, but they can within that think long term. And they should think long term, and they could think more sort of broadly about, the corporation isn't just the shareholders. The corporation is this complicated, web of multiple constituencies if you're good to employees, or if you're good to the environment, and that ultimately helps the financial bottom line. What I was saying about the should there be like progressive law, reforms at the corporate level, I think that is number one, unlikely. But also number two, that would be to require companies to be affirmatively more sustainable, which is not what I think the law says. I think corporate Delaware and everywhere else corporate law is like largely this sort of permission structure within which companies can manage the company however they see fit within this sort of wide range.
Okay, so I'm going to restate a little bit what I think he said, which is really in the long term, it is about shareholder value maximization, and which is fair. And that though, you know, kind of leads to all of this. The reason I've been focusing on this, right, is because so much of this, the political reaction, and I want you to come to that momentarily, against ESG, is the idea that this is not about shareholder value or maximization, especially when you're looking at pension funds and that sort of thing. And yet, if you go into the corporation, if you look at the legal counsel to the corporation, if you look at, you know, what the SEC is planning to do with climate reporting, the argument is it is all about that, right? All of this is actually financially material, and it matters. And as you pointed out in this, I mean, it's so hard to get through that business judgment rule, you know, in litigation. How on earth can it be challenged? And I think it's not a surprise that the Revlon cases, the reason those are, as you put it at the takeover level, is that is when shareholder maximization becomes very specific, right? And all the lawsuits are, you didn't take this offer, but you should have taken that offer, right? Because it's actually pushed down to monetary terms. So all of that makes sense. But again, and so this is more a comment, I guess, than a question. I just think that clarity is really critical in this whole debate about what ESG is, what ESG reporting is, what corporate sustainability reporting is. As you point out, empirically, it looks like, you know, that companies that do this tend to perform better in the long term. That took a bit of a hit last year after the post-COVID boom, but you know, I still think along the way there's that. So I'm sorry, I will stop nattering and turn this into a question.
Okay.
What do you think about the political backlash? Where do you see that heading?
Okay. One quick point before I answer the question about, I didn't say that there is this long-term wealth maximization obligation under Delaware law. It has to benefit the shareholders, but it doesn't have to maximize shareholder wealth. I mean, and for years before maybe the 80s, you know, companies were happy to make money, but they weren't kind of like going crazy about it. And I think that's more consistent with the sort of long-term obligation. How you can't disregard the shareholders. It has to benefit the shareholders in the long term, but it doesn't have to maximize their returns, which would be hard to police. As far as the political reaction, I think it's sort of proof that we're coming around, like on other issues, that in addition to challenging, you know, wokeness and equality and voting and whatever else is, you know, part of the platform for some of these people on the right, they're also, you know, challenging this ESG concept. I think what I saw about New Hampshire, even though it's not like Texas and Louisiana, a refinery state, is that, you know, by eschewing ESG, they lost a bunch of money for their pension fund because they were, you know, affirmatively ignoring it, and ignoring the business case for corporate sustainability. And so,
actually,
like,
let me inject something here, because I want you to continue to talk about this. What you're talking about in New Hampshire, what's interesting is about some of these state laws in Ohio. We have one that's proposed, or one that's proposed in Ohio now. Is that it specifically says don't use ESG, but it also specifically says that you have to take into account the best interest of the shareholder. So assuming that considering ESG is the best case of the shareholder, have you really changed anything? Right. So in any event, that's a comment I think that's interesting, because we know people losing money in Texas and that sort of thing by not being able to do business with BlackRock, blah, blah, blah. But you still get down to that conflict. Can you not consider ESG, obviously, if you are maximizing shareholder value?
Right. Yeah. I mean, I think the argument for ESG if you don't care about like the environment and you don't care about people, you should still care about ESG because it is, you know, an indicator of a business that is better and is going to make more money. And so, like, if you are, you know, just economically focused and your only goal is to make money for your investors or your trust beneficiaries or, you know, your state employees like you and me, then you should be taking this stuff into account. I mean, there's sort of, you know, a category of of corporate sustainability that is profit sacrificing, but most of it is not profit sacrificing. Most of it is profit generating, and you would be foolish to ignore it. And so, you know, maybe it's just sort of rhetoric and talk, and they want to have a you know, a headline and say we're not considering this stuff. We're only going to look at financial considerations. But you know, guess what? These are in truth financial considerations, and you ignore that sort of factor at your peril. Like, I think you would be a bad trustee, you would be a bad investment advisor, you'd be a bad corporate director if you just you know, on principle said, you know, we don't care. I think Louisiana said, well, we need to support the oil industry, and that's why we're going to you know, run the other direction from ESG. As a member of the you know, as a pension beneficiary, I think that's a bad idea.
Right. So you're preaching to the C-suite now. So again, I have many other discussion points, but I want to make sure people get to ask questions. We've asked people to ask questions through the chat, but also if you want to raise your hand, we're a relatively small group, and so that would work as well. I just want to give people a chance to ask Professor Sneerson any questions about his presentation before I continue to badger him with other questions and or comments. Anyone?
May I make a comment?
Yes, and who are that is?
I am Doris Rodriguez, and I'm
Hello.
hello. How are you doing? It's good to
Good,
see
thank
you. For practicing attorney here in Houston for many years, and I do practice corporate law. And I think it's pretty simple, frankly. I don't know that we need to be changing laws or having litigation about it. Perhaps we do because some people are so recalcitrant, but the fact of the matter is that there was never any law that required corporations to make as much money as possible. And there was never any concept that making as much money as possible was the only thing that could benefit a corporation or its shareholders. And so you're exactly right, both of you, that for the benefit of the shareholders has to include the reducing litigation risk and long-term benefits. And so if you didn't make as much money this year, right, because you were doing something to avoid those two things, as well as making as much money as you know you reasonably can under all of the circumstances, including ESG, then that's okay. And you know, for a long time we've had this concept, and I was on the board of St. Luke's Hospital, one of the major hospitals here in Houston. You know, we have a concept of you do well by doing good. And you know, I think it's so interesting to me that we see all of this back and forth on something that is really not an issue from a legal viewpoint. And I agree that saying that you're not going to, you know, pay any attention whatsoever to ESG, even in one of our states like Texas, that is truly an oil and gas state, as is Louisiana, it's just silly. At the end of the day, you can't do it. The public won't let you do it. Your shareholders at some point won't let you do it. And investors as well. They'll just fall out at some point. Thank you.
Oh, thank you. And that last remark especially is you're referring to the market discipline. Judd, do you have any responses?
Yeah, I mean, I think thanks for the comment. Yeah, I agree. I mean, I think that one of the things I'm fighting against is this notion that some people, including lawyers, including kind of corporate social responsibility minded people, have as well. I want to do good by do well by doing good, but my understanding is that from this one case that I remember from corporate law, Dodge versus Ford, that I can't do that, or I got to basically leave that at the door, and once I go into work, I have different responsibilities to the shareholders, and so fighting against that in terms of no, that's not what the legal requirements are. You don't have to sort of sacrifice your morals and your the environment and so on, and so you can do that, and also sort of educate on the market side of things. Even though I'm a law professor, just reading the studies from the finance journals suggests that there's money here. It's not always or even usually profit sacrificing. It's usually profit enhancing.
Yes, I have one more comment. I wanted to see though, Aubin, if you needed to show the CLE thing on this screen as well. Let me make spot. There you go. So hopefully everyone can see that. You can scan the QR code, and there is also the course number, which I think is important as well. This is for Texas CLE. Other CLE, you would need to file that yourself.
And I said the word ethics a couple times, so maybe that counts extra.
Well, I think this is a very big ethical question, quite frankly, and you're hitting on it when you say that some younger folks are not wanting to go work in corporations or work for corporations, or work for law firms that work for corporations that are not taking the fate of the world seriously. I do have one more question, which may close this out, but maybe if there's still a chance for other questions, that's fine too. And it goes back to the benefit corporation. So, and also to the idea of profit maximization. So one of the arguments, the structural arguments for, and I think Friedman sort of mentioned this, for focusing almost exclusively, right, on profits of the corporation or shareholder value in that sense, was that that's the one thing that's measurable, right? That's the one thing that's measurable. And so because of that, that's the one thing a court can look at, just as we're referring to the Delaware cases in terms of acquisition or purchases. That's the one thing that is objectively comparable. And I think for the purchasing of a corporation, maybe that becomes a little bit clearer. One of the advantages I do see to the benefit corporation, which I'd like to hear you say this, and even for nonprofit corporations, because there are state laws that allow nonprofit corporations, is they have to define their stakeholders. And so you can evaluate what they're doing. And so I think probably we're not gonna, it's very hard to litigate, Warby Parker says we're giving away glasses for free. Well, are you doing it enough? Are you not doing it enough? But at the same time, it strikes me that in the benefit corporation, that identifying the stakeholder or identifying the good or the goal is important in terms of at least somewhat, being responsive, I guess, right, to your shareholders. Is that true? Is that something, because you could have a general corporate law that says, and this is what I've seen, right? Stakeholders are the shareholders. They're your local, the local where you're located. They're your customers, and they're the world, right? You can have that big, broad definition. But outside of that, isn't it important to identify what you're trying to do if it's something that's beyond shareholders?
Yeah, I think like the clarity is important, and then reporting periodically, like benefit corporations are supposed to, about how they're doing on that other mission. is also important. And I mean, maybe there's a market check, different market, right? But if a benefit corporation isn't doing enough, then that money will find a different company. Just like if some conventional corporation is not making enough money or having too many accidents and too many people dying, or disregarding their sort of obligations as a citizen, then that money would find a different company. Of course, that's difficult with a mutual fund like most people are invested in, but there's a market response to that stuff as well.
Excellent. So any other questions? Well, I'm going to give it to you to wrap up. This is so interesting. You've been looking at this stuff for a long time, and I certainly appreciate your emphasis and your focus, as also, thank you, Ms. Rodriguez, about it doesn't have to be, complete wealth maximization for shareholders. And I think that has been lost in a lot of these debates. So I think that's very important to bring that back to the discussion. So I will let you close this out, and then I think Aubin will post the CLE slide for the remainder of the time. Thank you.
Okay, thank you, Victor. I hope this has been helpful and informative. And as I was saying in the Q&A, that it comes across that this is not a legal requirement of businesses, and not even the best way of making money if that's your priority. And so there's a better way of doing business, and hopefully we are coming around to it. And sort of a side point that if anyone has any additional comments, please reach out to me at Southern University Law Center, and my email and everything is accessible on the Southern University website. So thank you again for having me.
Thank you.